Good morning. Good morning, everybody. We're going to go ahead and get started. If you see people outside, go ahead and shoo them this way. All right, welcome, everyone. We are here today for our 32nd annual Texas Forensic Mental Health Conference. This year, our whole conference is the entire week, starting yesterday. We actually started on the Vernon campus yesterday for tours, and we're going to end on the Vernon campus Friday with Dr. Fabian. Tonight, we are having our event from 6 to 8 at the Red River Valley Museum. Everyone that has pre-registered, we appreciate you, and we're excited to see you tonight. And then the rest of today until 5, 8 to 5 on Wednesday and 8 to 5 on Thursday will be here at Wilbarger Auditorium. We also have a couple satellite locations throughout the state similar to last year that we'll be watching as well. We have a few auditorium rules that we'll go through. The exits are located to the back of the auditorium. There's only going to be one middle door. We actually placed trees in front of the other doors, so please don't move the trees to get out. We also have exits on either side, and you can see the exit signs right there. We have a young woman standing where one exit is, and then right over here to my left, there's going to be another exit. Restrooms are located outside to the left of the registration table and to the right of the registration table. We also have restrooms upstairs. Your mask is mandatory unless you're speaking up here away from everyone. We have hosts, just like we do every year. They have a red ribbon on their badge. They may come around. They're good for asking questions, but they also may encourage you to wear a mask, wear it properly, okay? We ask that you please silence all of your electronic devices at this time, and please do not bring any food or drinks into the auditorium. Our conference speakers are scheduled to begin typically at 8 a.m., so please arrive promptly. If you would like to speak to one of the speakers after each session and you want to come up on stage, please be mindful of social distancing guidelines, okay? Lunch is going to be on your own from 12 to 1 every day. Outside in the foyer, if you're not from Vernon, there's going to be a list of restaurants that you can look at and even a map. There's also going to be one in your book. During the day, a refreshment room is set up in the Empire Room. That's, if you walk directly out of the auditorium, it's to your left. We have snacks, we have drinks during break. Again, please be mindful when you're eating, you're taking your mask down, so just be mindful of social distancing. You're always welcome to eat outside too if it's nice. I think today's going to be a nice day. Just don't bring those food and drinks back into the auditorium. Please be mindful of the lunch break that's from 12 to 1 and return promptly at 1 so that we can get started with our next session. The CEU participant packet. So everyone should have registered this morning by signing in and received a book and a stapled packet, okay? Now your book is gonna have all your PowerPoint slides, any handouts that the speakers want you to have, and a notes page. Your stapled packet is gonna be the key to getting you CEUs at the end of this event, okay? And signing in. You are required to sign in for each session. So if this session ends at 10 and we have another one from 10 to 12, please remember to sign in at that one too so that you can get all your hours. Successful completion. This is a CEU event, so there are going to be certain things that we have to receive back from you. You have to sign in at the registration table, just like I said, and you have to attend the entire event. You have to complete the evaluation and the attendance verification form. There's going to be a bucket set out front, and you can actually turn those in when you leave each session, or if you plan on staying the whole week, turn them all in at the end of the week, okay? I have to show some certain slides. I'm not going to read through every single one of them, but it is about the CEU disclosures. They're also inside of your booklet. I will show them in a moment when this starts working. There we go. Okay. All right, non-endorsement statement. Accredited status does not imply endorsement of any commercial products or services by the Department of State Health Services, CEU Service, Texas Medical Association, or the American Nurse Credentialing Center. The speakers did not disclose the use of products for a purpose other than what it had been approved for by the Food and Drug Administration. And then we have our continuing, sorry guys. We have our continuing education statements that, again, these are going to be in your booklet. Should you have any questions about how to complete any of that paperwork, or did you sign in, did you forget to sign in, a host can always help you with that. And again, we have hosts set up at the registration table, and they also have the little red host badge right here, red host ribbon underneath their badge. So don't hesitate to ask somebody for help. We want you to get all your credit hours. There was also a change to our number of hours we're getting for ethics. We had originally thought it was only going to be 13, but it's actually 15. So if you have more questions about that later, get with the host because we are offering 2 more. So I'm going to hand it over now to James Turner, who has some way more fun, exciting things to talk about.
Good morning. How's everybody? How about a round of applause for Ashley? So, I'm here to give out the cool little welcome gifts. Who wants to win a prize? Does anybody want to win? Raise your hand if you want to win something. All right. So, we have these cool welcoming gifts, and they're going to be given out in your name. If you signed in on the sign-in sheet this morning, that's how important it is to sign into every session, because we're going to pull random names, and you're going to win this little box right here. I don't know if you could see it, but it's got a bunch of cool little trinkets in it. So without further ado, now when I announce your name, you have to make some noise and you have to really cheer, because you might not win. All right. So, Brittany Long. All right. First one out of the box. So, if you're upstairs, you can retrieve your box downstairs at the front. So, if you're downstairs, we have runners here that's going to run you a box. So, Barbara Wiebe. All right. John O'Neill. All right. Monty Hopper. Monty Hopper. Is Monty here? All right, upstairs, okay. Melissa Alexander. All right. Yes, y'all cheer on. Kimberly Busing. Kimberly, where are you? Kimberly. Okay. Rhonda Holler. Madison Copeland. All right, Madison's right here. Amanda Bivens. And that's it for this morning. So we're going to give away some more, so stay tuned. Don't forget to sign in, and I'm going to turn it over to Mr. Jim Smith.
Good morning, everyone. We've been doing this conference for a long, long time, and it's something that's become part of the tradition of our hospital. And I'm very glad that you all are here with us. I don't think you're going to be disappointed. I believe this is one of the better conferences that we've ever planned. I think even in the midst of a pandemic, you're going to find this is absolutely top flight, and we're glad you're here to share it with us. There are so many people that I want to acknowledge, and I like to do this at the front end of the conference rather than at the end. So people get an opportunity to thank the ones that are really responsible. Kelly Boyd chaired our conference planning committee this year, and I think she's done a tremendous job. Kelly, if you'll stand up, and then let me invite everyone else that, Ashley, I know you worked very, very hard. All of you worked terrifically hard. So please stand up so we can acknowledge what you've done. To all of the people who have signed on remotely, I want to welcome you as well. I know some of you felt more comfortable not traveling and continuing to observe good infection control protocol. My hope is next year you'll be able to join us in person, but for now, welcome. We're very glad that you've signed on. It's my honor now to introduce this morning's speaker, and it truly is a privilege. I've been working in public mental health since 1975. It's been a long time. And during all of those years, I've met many people who are involved in one way or another with the public mental health systems all across this country of ours. And a lot of those people during all of those years have been involved in one way or another in forensic mental health. So I've heard a lot of people speak on a lot of topics. I've crossed paths with a lot of experts in all of those years. And I can honestly say that I can't recall ever meeting someone who is so incredibly accomplished, yet so humble and so unassuming than our first speaker, Professor Brian Shannon. I want to take just a few moments and go over some of the things that he has accomplished. And trust me, this will be a short list, but I just want you to get a feel for the contributions of this person, and why it is such a privilege for me to be able to introduce him. Brian Shannon is a Paul W. Horn Distinguished Professor at Texas Tech's School of Law, where he has been on faculty since 1988. He earned his J.D. from the University of Texas, graduating first in his class in 1982, and he holds a Bachelor of Science degree from Angelo State University, where he graduated summa cum laude in 1979. He is a veteran, and as a veteran, he practiced in the Office of the General Counsel to the Secretary of the Air Force at the Pentagon, and later at the Austin office of the former Hughes and Luce law firm. Professor Shannon serves on the Texas Judicial Commission on Mental Health, and he previously served on the Texas Governor's Committee on People with Disabilities and is chair of the State Bar's Disability Issues Committee. Locally, he is on the board for Star Care Specialty Healthcare System And if I'm recalling correctly, in the old days that would have been Lubbock Mental Health Mental Retardation Center. And he is a past chair of that board, and he is a past president of the Lubbock Area Bar Association. He is also Texas Tech's faculty athletics representative to the NCAA and Big 12. In that role, he served 3 terms as the president of 1A FAR. That's an organization of the faculty athletics representatives from across the United States. He served on the NCAA's Division I Governing Council and is past chair of the Division I Legislative Committee. He is the author or co-author of numerous articles and books, including 6 editions of Texas Criminal Procedure and The Offender with Mental Illness, an analysis and guide. He has been recognized as an integrated scholar at Texas Tech. He has won numerous campus awards, including the Chancellor's Council Distinguished Teaching Award, the President's Excellence in Teaching Award, the President's Academic Achievement Award, the Faculty Distinguished Leadership Award, and the Barney Rushing Distinguished Research Award. Professor Shannon has literally received the highest honors that Texas Tech University system can bestow on a professor. In October of 2020, he was bestowed the Governor's Trophy by the Governor's Committee on People with Disabilities within the Office of the Texas Governor for, begin quotation marks, significant contributions to disability rights across the broad spectrum of disability, and for his work at the intersection of mental health and the legal system, close quotation marks. With again, great pleasure, it's my honor to introduce to you Professor Brian Shannon.
Thanks so much, Jim. Thanks so much, Jim. I think I ought to just sit right back down. I wish my mom would have heard that. It's great to be here, and what a wonderful space this is. I may be standing too close to this other mic. Woo, we're good. Wonderful space, wonderful auditorium. I feel like I ought to ask you all to stand and join in the singing of the national anthem, but appreciate your being early birds and out here this morning to start the day listening to a lawyer and law professor talk about Texas statutes for an hour and a half. Woo! You're probably more interested in who's going to be the next football coach at Texas Tech. I don't have inside information, but we'll be watching along with you. Delighted to be with you today, and it's great to see Jim as well. I first had the chance to work with him. We were reminiscing about this morning in 2002. The legislature in the 2001 session had enacted a study committee, a charge to take a look at competency proceedings in the state of Texas and to make recommendations on revisions to the old statutory framework that was then in place. As part of that work, we had hearings around the state, including hearings at the state hospital. And early on, we decided that the law as it existed then was so convoluted that we just needed to start over. And so Chapter 46B of the Code of Criminal Procedure was the outcome. It is a challenging set of statutes itself, but believe me, it was far superior to the approach that had been taken before. And so this morning I want to take some time and work our way through several different areas. And Jim mentioned that I'd served time in the Air Force, and some of you who are also veterans will know the old staff sergeant's approach. First, you tell them what you're going to tell them, and then you tell them what you told them. So we're to that first phase now. The quick overview of what I plan to try and cover with you this morning. First, looking at some key legislation from the last 3 legislative sessions in 2017, 2019, 2021. Because in my view, this is an exciting time from a policy wonk perspective, because for too long, persons with serious mental illness, persons with IDD, those who got caught up in the criminal justice system tended not to get a lot of attention in Austin with the state legislature. But we've seen significant change in that regard in the last few sessions, in that the legislature's taken an interest. There have been positive policy changes, as well as some funding improvements. Obviously, more would be welcome. Do want to talk a little bit about the Texas Judicial Mental Health Commission and some of why it was created and what its goals are. I've been proud to get the chance to serve on that since it got started a couple of years ago. And then work my way through some of the key provisions of Texas mental health statutes and laws as applied that impact what you do each and every day. And it's interesting, just, not quite 2 weeks ago, I had the opportunity to speak on recent legislation at the Texas Judicial Mental Health Summit. Did any of you go to that or watch online? Yeah, if you get the chance in the future year, last year with COVID, it was fully online like this conference was. This year, there was a streaming option as well as in person. And although the focus is the judiciary, lawyers, prosecutors, it's broader than that. And I know a number of folks involved in the mental health care system participated as well. And so I'd encourage you to look at that in the future. But anyway, my talk that day was for an audience of primarily lawyers and judges, right? And so it's refreshing to talk about it in this context with all of you who actually have to live with these statutes in what you're doing and dealing with real people on the front lines outside of the judicial process. So, thinking about the legislative efforts, we've seen a number of amendments in each of the last 3 sessions. And so starting with the 2017 session and some of the provisions that are there, we've got to keep in mind we have continuing challenges with the criminal justice system, as you know, in effect, largely operating a second public mental health system. The 2 largest public mental health facilities in the state in terms of overall numbers, are not any of the state hospitals, but are the Harris County Jail and the Dallas County Jail. And that's not something we should be proud of in terms of trying to address better outcomes for persons with mental illness. Yet we've seen over time this almost trans-institutionalization of individuals from public mental health type of sources over to criminal justice, where oftentimes community resources and attention have been lacking. Now that's improving, that's changing, but it remains a challenge. And so a lot of the legislative efforts have been focused in particular on areas of first contact when law enforcement's involved, initial detentions and court hearings, and then activities by the courts themselves. And so in 2017, we saw a couple of major pieces of legislation, Senate Bill 1326, and then the Sandra Bland Act, both of which had some mental health changes, and we saw some funding through some mental health grants. Senate Bill 1326 did several things, and part of what it was intended to do was look at the front end, at first contact, when somebody gets initially caught up in the criminal justice system, and to explore further and identify further ways to both identify individuals and preferably, if possible, for nonviolent types of offenses, divert. And so it impacted things like magistrates' duties, revisions to certain provisions of the Code of Criminal Procedure that are largely pretrial types of provisions, some changes to the competency statutes, and some changes on return to court. So let me highlight that last one first, looking at some of what the court's going to do and actions the court's going to do. The statute tried to focus both at the front end and the back end. First, at initial magistration, that is, after somebody has been arrested, booked, and then they're taken before a magistrate judge, could be a JP, could be in some counties a associate judge who's appointed for the purpose of this initial type of magistration. There, at that hearing, the judge, the magistrate, needs to determine whether there's been any kind of notice that the defendant has IDD or mental illness. And that notice should be coming from the jail or elsewhere. If that's the case, then the judge is to go forward and assure that these procedures under 1622 and 17032 are followed. Well, the magistrate's supposed to act promptly, act quickly. The scope of these statutes includes greater emphasis on this front end. Now, pausing, what are we talking about? With 1622, this is a part of the Code of Criminal Procedure that's been with us for a while. It had first been enacted in 1993, became effective September 1 of 94. Yet it was little used until, I'd say about 6 to 7 years ago, the Commission on Jail Standards added compliance with this provision to their report card for jails. So the Commission on Jail Standards does an evaluation of the various 240 jails across our 254 counties in the state, and they take steps to assure they're in compliance. Well, previously they had not taken a look at the jail's activities with respect to 1622, and suddenly they started doing it. Well, a number of sheriffs then were contacting their representatives and others saying, well, what's this new law? What is it we're supposed to do? Contacting local mental health authorities. What is it we're supposed to do? What is this about? And they were told, well, it's not new. It's been there, it's just not, and had not been used much. Well, then the legislature got to going into that session in 2017, that there were a number of timelines and the like that didn't make a lot of sense if the whole purpose is to do some quick identification and screening of whether somebody who's been arrested might have a mental illness. So the changes I've highlighted in red there on the screen, where the sheriff now or a municipal jailer has to notify this magistrate judge. Used to be 72 hours, used to be within 3 days, but the sheriff has to notify within 12 hours upon receiving credible information that might establish reasonable cause to believe that a defendant has a mental illness or IDD. And it applies to charges of Class B misdemeanors and up. So it doesn't include Class C charges where there might be an arrest for, say, multiple tickets or the like. Well, where's the sheriff going to get this information? Well, from what they see. They do a screening interview when they first apprehend an individual. It's not a true mental health evaluation, but there's some standardized screening instruments that are used. They should be doing a check of the records to see if this person has had the CCQ query, it's called continuity of care query, to see if the person has prior contact with the state public mental health system, whether at a state hospital or through a local mental health authority. They should also be checking their records to see if this individual has been arrested previously and whether there's any kind of 1622 report that's been on file in the prior year. All of this should happen early on, shortly after arrest, where the sheriff then has this obligation to report back to the magistrate. To make it easier, the legislature specified that Tomi, the Texas Correctional Office on Offenders with Mental or Medical Impairments, should create a standardized one-page form for doing so. And they have, and it's available electronically, and that form is used. So, what does that mean? Magistrate gets this. The magistrate then is going to order that information be collected from the individual to get an idea of three things. It's pretty straightforward, pretty directive. It's not a true mental health or IDD assessment as people in the profession would be thinking about it. Instead, it's just an identification. Is there information that indicates that the person has a mental illness or is a person with IDD? 1. 2, are there some current treatment needs? 3, might there be a need at a later point to order a full competency evaluation? Those 3 simple things. The information has to be collected quickly within 72 hours, can be done by a representative local mental health authority or other expert appointed by the magistrate to do so, can be handled through an in-person interview at the jail, could be handled by telephone. It's been greatly simplified. Used to have to happen within 21 days. Well, that was a long period of time if you're trying to do an early identification of somebody with a mental impairment. Now that's been shortened to 72 hours. So 12 hours for the sheriff to notify the magistrate. Magistrate is supposed to handle this promptly, issues an order. The interview has to happen within 3 days. Doesn't have to happen if there's been a report on file in the prior year. Not surprisingly, a number of individuals, as you know, who have serious mental illness might be getting picked up on misdemeanor, other nonviolent criminal charges on a relatively frequent basis. Charged, released, not doing well with their mental illness, and get caught back up in the criminal justice system. So, highlighted already a couple of things that need to be in the report. At one time, it had language like assessments, talked about the amount of time that could be provided. That's been amended as well, in terms of these findings that are identified. Well, what's the relevance of these findings, and so what? We've got these findings, it comes back to the court. Well, the court has some opportunities, some tools, some steps that can be taken. One that's existed since the early 90s when this was first enacted and continues to be a part of the law is an ability to turn to the personal bond sections of the Code of Criminal Procedure, and the judge can make a determination about whether or not this person could be released on personal bond with a mental health treatment condition. Now, this was a laudable effort by the legislature in the 90s, as repeated with these 2017 amendments. There are still practical aspects and practical considerations. There has to be close coordination with the local mental health authority to assure that such services are available. There's a long laundry list of violent offenses where this is not available, and that makes sense. And then the legislature, during this second special session, I'm trying to keep up, there were 3. During the second special session, one of the bills that passed was a bail reform bill. And part of that made some tweaks with respect to when personal bond might be available. By personal bond, I just mean no bail. There were some additional violent offenses that were identified where a release on no bail, a release on personal bond would be excluded too. But for a wide array of nonviolent offenses, what this statute would permit would be release of the individual while charges are pending without bail, but with the imposition of a mental health treatment condition. The hope being that the individual would receive such treatment during that time, would do better, and then perhaps avoid further need for criminal prosecution. Now, backing away, recognize that 95% plus of all criminal cases don't go to trial. There's going to be plea bargaining. They'll plead out for some types of either lesser charge or perhaps a dismissal of charges. And sometimes, particularly when nonviolent offenses committed by a person with a mental illness, particularly if it's a first offense or there's no, obviously no violence involved, the prosecutor may be very willing to look at the possibility of some sort of dismissal of the charges in exchange for an agreed treatment plan, provided that the defendant can show that, hey, yeah, the person does pretty well with care and on treatment. So these are some possibilities that are present. And it's interesting in terms of the timing for this presentation. The deadline for getting my materials in so that you could get your CEUs was a couple of months ago. And so one of the bullets on this next slide highlights something here new in 2017. List of violent offenses was narrowed to exclude simple assault except for offenses involving family violence. Well, that got tweaked a little bit in the second special session, which took place subsequent to these slides having been turned in. And let me talk about that just a little bit. So somebody's not doing well, police arrive on the scene, and as part of acting out with the symptoms of the person's mental illness, say it's a nonviolent offense like trespass or loitering in some sort. But the defendant acts out, perhaps pushes someone or pushes the officer who arrives. Well, one of the things that had been excluded previously from the list of so-called violent offenses where this release on personal bond with a treatment condition was any kind of assault. Not just aggravated assault, but even a simple assault. Well, assault could be a swat on the arm, something that might leave a redness of coloring, perhaps, maybe a bruise, maybe not, but could be just an offensive touch. That could count as a possible assault. It could be charged. Well, the legislature decided, yeah, that's a little broad here. We ought to carve out and permit the opportunity for a treatment condition being imposed, release on personal bond with assault. Well, then along comes Senate Bill 6 in the second special session that added some different offenses for which release on personal bond isn't allowed at all. And one of those was the potential for assault if the assault happens to be an assault of a peace officer or a judge. That then could be charged as a felony, and that's now excluded from the possibility of bond. Well, certainly we don't want individuals assaulting police officers or judges. But there's assault and there's assault, right? Was it just a push as the person is being apprehended, or has the officer been struck in a violent fashion? And so it's now incumbent on prosecutors, as they look at what level to charge the individual, to take into account whether or not to proceed with that level of assault offense or not. But if they do charge at this higher level, then there could not be a release on personal bond with the opportunity for some type of treatment condition. Well, some additional changes were made to Chapter 46B. And Chapter 46B, as most of you know, is the set of statutes that describe and define the competency restoration process. And more on that in a little bit, but I wanted to start by highlighting some of this recent legislation. And what this statute did, among other things, was to add more opportunities for jail-based competency restoration. We all know that the backlog, the wait lists for competency restoration inpatient beds in this state is very long. And so even as early as 2017, we saw some efforts in this regard to expand the ability to have jail-based competency restoration, in part to take some pressure off of the wait lists on the state hospital. Now, prior to 2017, there'd been legislation that former Senator Duncan had introduced, that passed, that allowed the state to create a pilot project for jail-based competency restoration, and it never happened. There had not been a pilot there, and some had contended is because the criteria for what the jail had to do with respect to the processes and procedures in place were so onerous that local mental health authorities weren't bidding, counties weren't bidding to try and be awarded such a pilot. So in 2017, this provision was added to 46B to create an ability for local governments, for counties, to establish jail-based competency restoration programs. And since that time, some have done so. There's, I believe, 5 to 6 now, I think 6 in existence. Lubbock is one. They don't have large capacities. Many of the jails around the state weren't designed so that you could have, in effect, a separate wing for purposes of competency restoration treatment. After all, what are jails set up to do? You know, not treat for the most part, but instead to incarcerate individuals. But some of the jails were so structured, some used some of the appropriations that through these grant projects, grant proposals that were made available in the same session to be able to expand that. Well, might have had a little dent on the wait list, then came COVID, and we know where the wait lists are today. So good start, but authorized doing this. A couple of other things. This is in Senate Bill 1326-2, where basically prompt action is needed. So you working at a state forensic hospital have done a great job. Defendant's competency has been restored, and then that person is transported back to the county, back to the jail, and all too often, we know what happened. The defendant languishes there in the jail for some period of time before he or she is brought back before the court for further action. There's supposed to be continuity of care in terms of a continuation of any of the medications that had been prescribed at the state hospital. May well be a court order for medication that still continues for several more months after the person leaves the hospital and is back in the county. But without prompt action, we have had far too many times where a person decompensates and is not competent yet again. So one of the things the 2017 legislation did was to say, hey, you got to queue these cases up right away, that the trial against a person who's been determined to be restored has to be given preference over other matters. And the statute's very clear on that. It has to be given preference over all other matters to come before the court, except for criminal cases where a victim is a child, where a victim's under the age of 14. Well, that's well and good. You also have another problem that I suspect you have faced here at the state hospital is somebody is restored, you alert the county that John Smith, Jane Smithers, restored, ready to go, come pick them up. And then the county doesn't act for 2 or 3 weeks to be able to get the person and take it back. Well, that's a problem, right? It's a problem for you at the hospital. It's a problem that the court needs to address with the county for not taking such prompt action. But that also creates delays. This statute in 2017 was intended to jumpstart and try and have a prompt resolution of the matter, but it's going to be up to, I mean, the judges aren't going to keep up with a lot of the days and who's back and when. It requires a team effort. It requires the court coordinator to be on top of that and working with the jail and identifying when individuals have returned. Another piece of 2017 legislation was the Sandra Bland Act that started out as a much broader proposal relating to a number of things after the tragic death of Sandra Bland. A lot of that didn't pass, but parts relating to mental illness did pass. And one, I think, laudable provision in there was an addition of Article 16.23 to the Code of Criminal Procedure that identifies, in effect, as a goal, is that each law enforcement entity, so police, sheriffs, should engage in a good faith effort to divert persons with mental illness or IDD in the case of nonviolent charges, nonviolent misdemeanors. Well, laudable provision, some great language in there, good faith effort, but there's no teeth behind it. There's no, you must do this. And so some law enforcement departments around the state have done a tremendous job and have made great strides in this regard. Others haven't acted on it, and there's not really any teeth. Another aspect of the Sandra Bland Act that was important and then got amended in 2021, so I want to take a moment and highlight it, is that the Jail Standards Commission, remember that's the group that does in effect, the report card of the jails. You got to do this to be in compliance with the standards. The Jail Standards Commission was tasked with providing 24/7 access in the jails for inmates to both health care as well as mental health care. Well, it seems fairly basic. I think that would largely be required by other laws to begin with. But this says, Jail Standards Commission, you're going to now assess on this. You're going to have rules that require 24/7 access, and that access can be by telemed or telepsych. So some jails, Harris County, Dallas County, some of the larger jails already had such access, but many of the state's 240 jails did not. So this was an important change. There were also increased training requirements for jail staff and peace officers with respect to crisis intervention actions, CIT types of training. In addition, in that session, there were matching grants made available for local governments to do things like expanding outpatient competency restoration, creating jail-based competency restoration, creating other interactions where, say, local mental health authority individuals would ride along with peace officers in community-type interactions with persons suspected of mental illness. We move forward then to some legislation in 2019, and a couple of those I want to highlight. Senate Bill 362 made amendments to some of the civil commitment statutes that clarified and simplified the outpatient standards and restructured some of the statutes. We don't see that as much in the criminal justice side, but we can. And there can be, in appropriate cases, particularly nonviolent offenses, diversion to outpatient types of commitment as an alternative, perhaps, to criminal justice. And that was further specified in what I'm calling a 1622 roadmap. And in that regard, another bit of legislation that had existed since 1995 is also seldom used. Some of you who are gray or thinning like I am on top will remember that there was a time where one could not get a civil commitment if any criminal charges were pending in Texas. And that was the law up until 1995. There could be an emergency detention, there could be an order of protective custody, but there could not be civil commitment if any criminal charges were pending. Oh, I think I went dead for a minute. I'm back. Okay. The legislature in 95 enacted a provision that said, hey, we're going to change that a little bit. You can't do a civil commitment if any charges are pending that involve an act, attempt, or threat of serious bodily injury. Well, what that did then was determine that you can have a civil commitment if criminal charges are pending against the individual, if the charges don't involve an act, attempt, or threat of serious bodily injury. Well, that was a big type of diversion opportunity, still not used very much. I remember getting a call sometime after that where one of the local jails in the Panhandle was trying, in the West Texas, was trying to get a person who'd been charged to receive civil commitment services at the state hospital in Big Spring, where there were criminal charges pending, and they were nonviolent. And so they weren't then aware of that change in the law, but a few calls, and that was there. That was able to be done. Now, one of the reasons I think this has been little used over the years is that these changes were in the Civil Mental Health Code and the Health and Safety Code. Well, what statutes do criminal prosecutors and criminal trial judges, what do they usually use? They know the Texas Penal Code really well, and they know the Texas Code of Criminal Procedure. They don't deal with the Health and Safety Code for the most part, or at least not traditionally. And so this mechanism for diversion that's over in the Health and Safety Code, well, that's something that usually a different office is using. The county attorney's office is the state's attorney for civil mental proceedings, or in some counties, the civil division of a criminal district attorney's office. Not the prosecutors, but a different state attorney. Often it's a different judge. It's the judge with probate jurisdiction. In many rural counties, that's the constitutional county judge. In larger counties, it may well be either the constitutional county judge or a county court at law. And in 6 or 7 counties, there's a statutory probate judge, the larger counties in the state, or more populous counties in the state. Those courts are the ones who tend to deal with the mental health code, not the criminal courts. So what the legislature did in 2019 was say, well, let's take some of that same concept and let's put it over here in the Code of Criminal Procedure, something we know the criminal prosecutors and judges actually use and look at. So 1622 was amended. Remember, 1622 is that quick screening where there's this report that defendant has a mental illness, may need this treatment or is receiving this treatment. And then what? Well, subsection C tells the judge a number of things the judge should do next, and a new section was added, C5, that I've got the second bullet point up there, that if the offense charged doesn't involve an act, attempt, or threat of serious bodily injury, the judge can enter an order to have the case, in fact, put the person on bail and ship the person over to the court with probate jurisdiction to look at doing an outpatient civil commitment. To do an outpatient civil commitment. So nonviolent offender, have this kind of referral for outpatient commitment. Now, that statutory authority already existed. In fact, the statutory authority is broader. The statutory authority could allow for an inpatient civil commitment. But we decided and I helped with some of this drafting, we decided for this provision that was enacted in 2019, we think we'll just mention outpatient here. And you know why that is, because there's just not much bed space for civil inpatient commitments right now because of the vast numbers of folks needing forensic mental health services. So the focus has been on the nonviolent offenders and outpatient civil commitment as a way to divert these nonviolent offenders out of the criminal justice system. Well, fairly new, passed in 2019, it's only been effective 2 years. A few courts are using it, and the Judicial Commission on Mental Health is trying to encourage broader and more use in that regard. There were a few further changes during that session as well, some clarifications to 1622 to talk about being an interview of the person, not an assessment, not a full-scale mental health assessment. And then something that the HHSC had sought was, and again, trying to be able to have some flexibility with respect to the inpatient maximum security beds versus other inpatient beds for forensic placements for competency restoration. Under the prior law, prior to 2019, as I think most of you know, whether or not that person had to go on the wait list for a maximum security unit or not depended on what the charges were. If the charges were an array of serious violent type offenses, then boom, the individual automatically had to then be ordered to the maximum security unit. But, professionals in the healthcare field assessing individuals certainly could be able to tell that, this person probably doesn't need to be in a maximum security unit, even though these are the charges, and there ought to be greater flexibility. And so that's what this statutory change did. The court just orders the person to inpatient forensic mental competency restoration services, but it's now HHSC's call as to whether the person should be, in effect, waiting for a maximum security bed or not. So it enhanced the security, enhanced the flexibility there. Another provision that passed as part of that session was to encourage more use of mental health courts around the state. Now, Texas has been a leader. We have more specialty courts than any other state. These have really taken off in the last 15 years. So we've got specialty courts for drug courts, veterans courts, mental health courts, juvenile mental health courts, even prostitution courts, other focuses of trying to have more involvement by the judge and the court where charges might ultimately be dismissed if the participants go through often a 2-year pretrial diversion program to stay connected to services. And I talked to one of the judges who operates one of these courts, and he said, his involvement, once somebody's on the docket for one of these courts, he said his role is pretty simple. He makes sure that all the persons come back before the court every 2 weeks. The entire treatment team and representatives from the prosecutor and defense counsel are present. And he said he asked 3 basic questions. He said, "How you doing this week? Are you taking your meds? Did you go to your appointment? Have you had an appointment? Did you go to your appointment?" And just with those almost 3 simple steps, that black robe effect, the judge being involved, has led to greater compliance with a treatment regimen, persons with lower recidivism rates who successfully go through the program, and data that shows they'll stay with services longer after the program is over, as opposed to not having that. So again, not huge numbers of people on the dockets of these, but more efforts, more funding at having more of them. There was also an ability to expunge a record altogether, to make it leave the records altogether for somebody who on a first time goes through one of those programs. Well, chronologically then, in 2018, the Court of Criminal Appeals and the Texas Supreme Court, and I think you're familiar that Texas, unlike almost every state, we don't have one single high court. I guess we're Texas. We do it different. We do it bigger. We have 2 high courts, the Texas Supreme Court over civil matters and the Texas Court of Criminal Appeals, and I'm off one slide. So in January of 2018, these 2 courts held a hearing jointly and took testimony throughout the day, talking about issues involving persons with mental illness, persons who are IDD, in the criminal justice system and in civil courts, and how the courts needed to pay more attention. Shortly after that, the 2 courts jointly created the Texas Judicial Commission on Mental Health. There'd been a Texas Children's Commission, still is. This is sort of a model. This is a sub-agency, if you will, of the courts. It's not a legislative creation like the Railroad Commission. But it's a commission reporting back to the 2 courts to try and look at issues involving persons with mental illness or IDD in the court system. And it's got a number of charges to try and help better educate the judiciary, better educate and inform the lawyers who appear before the courts, as well as to make proposals for revisions to rules and statutes with respect to the wide array of issues of a legal sort involving persons with mental illness. And so that was born in 2019 during the middle of the session, and then leading up to the 2021 session, the commission came forward and recommended a number of provisions for statutory changes, many of which then got incorporated into a couple of bills, in particular Senate Bill 49, and a goodly number of these things passed. So let me highlight some of those. Those 1622 interviews, the whole goal was to look at persons who are in jail who might have a mental illness or IDD, and should something then be done with those individuals. Well, according to the strict terms of the statute, the counties were supposed to also chase down people who might have already been released on actual bail. That didn't make a lot of sense if the whole purpose was to sort of divert them from jail pending any outcome of the criminal process. So the Meadows Mental Health Group recommended that that change be made, and that was changed. There were also changes to the jail-based competency restoration provisions, including some issues involving deadlines for evaluations, and more on that in a little bit. Something that could involve some of you in the audience is there were changes to expert qualifications in insanity defense cases. these were fairly minor and technical, but sort of an interesting background. When 46B was first enacted in 2003 and became effective in 2004, it set forth the now familiar requirements for forensic psychiatrists, forensic psychologists to be able to be appointed to do a competency evaluation, be appointed by the court to do a competency evaluation. Well, these included certain levels of training and certain continuing education requirements. We also recognized that there were some very capable, excellent docs out there who might not meet the qualifications as specified in the new law, but who should nonetheless be grandfathered in for a transition period. And so we had a grandfathering provision in there for those who had been conducting forensic evaluations for at least the 5 years preceding the enactment of the statute. In the next session, in 2005, 46C was adopted, and those are the provisions relating to the insanity defense. The exact same qualifications for psychiatrists and psychologists to be able to do insanity evaluations was passed as part of that statute. It also had a grandfathering provision. Well, rock along some years later, we're well past the 5 years needed for grandfathering. The statute's been in place for a long time. A bill was passed one session that amended 46B in some other ways, and while the legislature was at it, they said, well, let's fix this, and we don't need the grandfathering provision anymore because we're well past that, and all the grandfathers would be in, and those requirements should apply. It never happened on the 46C side. And so the thinking was, man, we're more than 15 years past when this was first enacted. There's no longer any need for this grandfathering provision. And the language in there was confusing. Like, what does this mean? And for those who hadn't been around when this had first been passed, there was some uncertainty by some of the courts. So that got cleaned up. And so now the qualification in 46B and 46C exactly line up and match. The next bullet point I want to highlight for a moment too is this possibility of psychiatric stabilization at the jail. Now remember, talked about how with the 24/7 access requirements of the Sandra Bland Act, that there needs to be 24/7 access to psychiatric services, whether that be in person or through telepsych. What was missing in that was anything to do about medications. Now, again, I think other laws, no doubt, in my view, require the local jails to provide and have available medications. But what we're finding is that, great, well, we got 24/7 access to a psychiatrist, a psychiatric nurse practitioner, somebody through telepsych, and they prescribe a med, and then they're not getting it, or the jail's not making it available. So what this bill did, and it was effective September 1, is it's required the Jail Standards Commission to set a rule that talks about having the meds that are prescribed available and provided to the inmates there at the jail who've had such prescriptions. Well, just passed, I understand the Commission on Jail Standards is having their public hearing or working through doing the rulemaking process soon. And so I think we can anticipate that. And I think the goal with that is that a number of individuals, again, particularly those charged with nonviolent offenses, if you can get them stabilized on meds while they're at the jail, you're not going to need a competency proceeding. You're not going to need further legal proceedings in that regard, and the case could be disposed of, whether it's dismissal or through plea, and move forward. So again, the hope there is, one, it's better in most cases for the defendants to have some opportunity for treatment. Of course, they might refuse. Then we look at whether or not a forced medication provision might be able to take place or not. But just having that available should be a positive. Another provision that was included in Dr. Floyd Jennings is one, the late, great Dr. Floyd Jennings, who sadly passed away this summer. He had recommended we ought to have some clear note of when does the clock start to run with respect to the clock for number of days for competency restoration. And there'd been some confusion by some of the courts. So what this statute holds, or what the statute now requires, is that the period, say the 120 days for felony or the 60 days for misdemeanor, that clock starts to run at the later of the date of the court's order or the date the competency restoration services begin. Well, we all know most of the time that's probably going to be the date that the services actually begin. So now we've got a clear identification, and Dr. Jennings had made that recommendation. One other provision, I didn't have a bullet on it on the slide, but there is another provision that now allows a potential for a possible step down for civil commitments for somebody who's still under 46B. So as you know, under 46B, and I'll highlight it again in a little bit, is that when the competency restoration period runs, and so say, take for example felony, you got the 120 days, you got one possible extension of 60 days. At that end of the 180-day period, there can no longer be a competency restoration commitment. At that point, if the person's still not restored, the court then has to proceed either under 46B 102 or 46B 151, depending on whether the charges remain pending or charges are dismissed. If the state refuses to dismiss the charges, then there is a civil commitment hearing under 46B 102 that's conducted by the criminal court. Well, suppose then that criminal court determines that, yes, the person meets the commitment criteria for inpatient. The statute goes on to require, again, whether or not that be in a secure hospital setting, maximum security type unit, but it has the possibility of a step down to another state hospital bed. What was missing in the provisions in 46B might, in appropriate cases, there also be a further step down to outpatient civil commitment in the community. I'm not sure it'll happen often, but it wasn't there, and it provides an opportunity to explore that in a particular case. Well, you've been hearing me ramble for an hour just on legislative changes. Let's delve in a little further on the broader statutory scheme and potentially, boy, I hate doing this. I keep turning around and see the back of my balding head, but oh well. So I'm going to walk through some of the civil briefly and then get to more of the criminal provisions. And I think it's helpful to think about a hypothetical. A few of you have heard me before. I like this hypothetical, at least try to put some of these complex, complicated statutes into a human context. And so let's suppose we've got Anne, and Anne's not doing very well. Anne's at a convenience store. She's come in, she's disheveled, has poor hygiene. She's muttering to herself. She's coming up to other customers and saying things that are strange. The other customers are getting nervous or shying away from her. And there's only a couple of employees there, and there's this 21-year-old clerk, and he tells Anne, you got to leave. You're disturbing other customers. And she says something back to him that just doesn't make much sense, doesn't seem to respond at all. There's something about Satan or the like, and so she still doesn't leave, and so what's this 21-year-old clerk at the convenience store going to do? Going to call the cops, right? Probably not calling a a mental health crisis outreach team unless that clerk has had this experience before and knows to make that call. In almost every community in this state and country, there's going to be a call to law enforcement. And law enforcement will respond. Well, change the facts a little bit. Instead of Ann in that condition, Ann grabs a six-pack and rushes out the door, exclaiming loudly that, I don't know, Satan's in the parking lot and he's thirsty. So now we've gone from possibility of trespassing to simple theft. Or we could expand it and Ann, on her way out the door with a six-pack, the 21-year-old clerk tries to stop her and she pushes past him and he falls down. Okay, now we've got the possibility of theft and simple assault. Or let's suppose that not a 21-year-old clerk, but a 65-year-old clerk gets knocked down. Now we got assault on the elderly. Let's suppose Ann's also brandishing a 12-inch Bowie knife. My wife and I rented a movie the other night, or were streaming a movie the other night, and the character was saying Bowie knife or something like that. I thought, come on, where are you from? But brandishing this knife happily doesn't cut anybody, but now we've got something even more scary, right? Possibility of an actual charge of violence. In all cases, the officers show up, and if I raise this hypothetical, which I probably did when I was last here 10 or 12 years ago to speak at the conference, where was Ann headed next? Probably in every community in this state and country, she was going to jail. Today, in a lot of communities, she might still be going to jail. But the officer on the street has discretion. And in the civil context, a process could start along these lines. And in particular, I want to note that the officers have discretion to do a warrantless emergency detention. And we're seeing in more communities with greater efforts at crisis intervention training, mental health sheriff's deputies, law enforcement who are specially trained in these areas, where, and particularly, maybe not with the Bowie knife, but in most of those other cases, the officer will exercise discretion to take Ann for a mental health assessment, to conduct a warrantless emergency detention at that point. For example, here's some of the first responders at Houston Police Department. The statute in 573, the Health and Safety Code, allows the officer to exercise discretion to take the person to a mental health facility instead of jail. The officer has that discretion. If the officer determines there that the person, in my case, Ann, has mental illness, there's a substantial risk of serious harm if there's not immediate restraint, the officer can form that belief from a representation of a credible person or on the basis of observed behavior. So the officer doesn't even have to observe it. It could be the clerk there at the convenience store or some of the persons who are there in the store. And I've done these trainings for law enforcement before, and sometimes there's a reluctance about, but could I be liable? Might there be some risk of personal liability? And the drafters of the Civil Health and Safety Code have another provision in Chapter 571 that says anybody involved in one of these processes, including law enforcement, if they're acting in good faith and carrying out their discretion under the statute, they're immune from civil liability. Does it mean they won't get sued? Well, sadly, I guess not for me because I'm teaching lawyers. Anybody could get sued. Doesn't mean there's any basis or liability, and I think any action along those lines would probably be a frivolous case and could result in sanctions for the lawyer because the officers have this discretion. Of course, the alternative is for an adult to go before a magistrate and seek a warrant. Hey, we're really worried about Aunt Ann or Sister Ann or Ann, who I've been treating at the local mental health authority. We can't persuade her to go get help voluntarily, believe she's a danger to self, others, or is deteriorating to the point of being dangerous to self or others. A magistrate can execute a warrant. My interest in the area goes way back to having a family member who went through this. My younger brother, when he was a senior in college, had his first psychiatric break, issues with what we then learned was schizophrenia. I was a young lawyer in DC at the Pentagon. He was a senior at Sul Ross and wasn't doing very well. And thankfully, his roommate probably saved his life in that his roommate got worried about him, called my parents, and my folks ended up taking him back to San Angelo where they were and couldn't persuade him to get help. He was not doing well, and whatever it was going on, it was no problem to him. He had agosnosia. Those of you who are doctors looking like Shannon, that's not how you pronounce it. He did not have insight, did not recognize that about the illness, but the county judge issued an emergency detention warrant, and that helped get my brother into services for the first time. Thankfully, my brother never ended up in the criminal justice system, but he first got ill, unfortunately, before a lot of the newer generation meds. And so we went as a family through this process multiple times where he would stabilize, but he was on some of the older generation meds, Haldol, others, very tranquilizing. He'd go off the meds, you know the story, would cycle back. And on his fourth hospitalization, was around 1990, he was at the state hospital in Big Spring when, thank goodness, Clozaril became the first, quote, new generation, it's not so new anymore, new generation antipsychotic to be available. It made all the difference for him. He responded well to that. He passed away a few years ago from an unrelated brain aneurysm, but the rest of his life he was able to live fairly independently with services from Concho Valley MHMR, never was hospitalized again. Clozaril for him was the right med and made a big difference. But having these tools in the community, law enforcement discretion, magistrates' warrants can help avoid the criminal justice process as if they are used and those local services are available. That process you're familiar with, I won't spend a lot of time with it, but to have an individual seen by a doc within 12 hours, the person can be held for up to 48 hours on an emergency detention, but longer if a weekend intervenes. And so depending on when the 48 hours starts, it could roll over into the next Monday, or if it's a 3-day weekend, to the next Tuesday. To hold someone after that, there can't be sequential emergency detentions. The facility is going to have to go seek and order protective custody, have the county attorney seek a protective custody order from a magistrate to be able to hold the person longer. And there's additional legal requirements tied to that and could lead then to an inpatient or outpatient civil commitment. The law changed a few years ago to make 45 days in effect the default, but the statute says it can go up to 90 days if the judge finds it necessary. I think, this is just Shannon, not part of the law, is if we're talking about an outpatient commitment in particular, the judge should, I think, often be thinking in terms of 90 days to have the opportunity for AOT, assisted outpatient treatment, to be more successful. And after all, the liberty interest is much less at stake with an outpatient commitment versus inpatient. The commitments could then extend to a year in the case of longer term, and where many of you here involved with the forensic hospital are aware, this tends to happen on the back end in those 46B longer term commitments. The other provisions relate to medication hearings. And here, this gets complicated. The Texas statutes on medication are a bit convoluted. They were changed a number of times. I think it took me about 40 single-spaced pages in a law review article for St. Mary's Law Review to walk through all the Texas statutes. So let me see if I can boil it down in a couple or 3 minutes. So when this law got changed some 2 decades ago, the judge has the ability to enter an order to order medications when the person refuses. Typically, in a civil commitment context, this would take place in a hearing that follows immediately after the civil commitment hearing. In the civil context, in the civil standard, the focus generally is on, does the individual lack capacity to make medication decisions, and is the med that the doc has specified in the best interest of the person? And then if you add in the criminal context, if the patient's been ordered to receive inpatient mental health services by a criminal court, that treatment with the proposed meds are in the best interest, and either the person is a danger to others in the facility, or one other mechanism, that ability is there too. So in a criminal type context, the discretion is twofold. One, about lacking capacity and best interests, or adding in with the criminal this concern about dangerousness. In addition, one provision that's A12 that I think it should be used more and is little used. What about somebody who has been adjudicated incompetent, ordered to inpatient forensic care, and then they go on the clearinghouse wait list? So, right, most of them, unless the local mental health authority has an outpatient competency restoration program or can move the person immediately into a jail-based competency restoration program. Now, there aren't a lot of those. So for most, somebody's been ordered then to inpatient forensic services, and they go on the wait list. And we know that it might be months and months before they move off that wait list. But this part of the statute was changed a number of years ago to give authority if the person is in need of meds and is refusing meds, that if they've waited as little as 3 days after that court's order, 72 hours, there can be a medication hearing about ordered medications. And some counties are more attuned to this and better equipped at doing this than others. I'd still say a majority aren't doing this. But for a number of individuals, if the local prosecutor and courts would go forward with this, they may well be able to have more medication orders entered and people being stabilized on meds and perhaps no longer have need for the inpatient competency restoration services. So I think it can be a little used or missed opportunity. Well, let's say that the officer hasn't taken Ann to the civil side, an emergency detention. Instead, she's arrested, taken to jail. Well, there's more diversion opportunities. If there's nonviolent offenses, there's the potential for pre-booking diversion. Harris County has started doing quite a bit of that. They have a program that they've got right at the booking desk. Mental health folks from the Harris Center, where they're looking at the possibility of diverting right then rather than booking them on into the jail. There's supposed to be the jail screening we've talked about. They're the 1622 options that I talked about things that have been modified of late in some of the statutes. They're the specialty court programs, mental health services at the jail, even the ability, if somebody is stabilized and there's the opportunity to plead them out, to include as part of, in effect, a deferred adjudication or probated sentence an order for treatment conditions as part of that. And so some defense attorneys and prosecutors are working together in cases where, say, Ann's identified and they can get Ann onto meds, and when she's been on a treatment program before, she's done pretty well. They may be able to dispose of the case that way. But all too often, we find in the courts that the courts are going to default right to going forward with a competency process. And yeah, that's constitutionally required before there can be a trial or before there can be a plea that the person has to be competent. But particularly for misdemeanors and nonviolent cases, there's a real push now by the Judicial Commission on Mental Health. In fact, at the conference 2 weeks ago, they released something called a toolkit to try and eliminate the wait. And when I get back to my desk, I'll forward the link to that to the Brittany and other conference folks here to be able to share that. This toolkit has checklists for the judge, the prosecutor, the defense lawyer, the sheriff, local police, local mental health authority, a number of things. Have you explored this diversion opportunity? Have you explored this one? Have you explored that one? To try and, again, take steps before somebody's just automatically shoved into the competency process to try and avoid lengthy types of delays. Because once the matter goes forward, charges are pending and a competency process starts, the level is pretty low. As long as there's some suggestion of incompetency and some evidence from a competent source, then the process will start. And as you know, it's a pretty complicated process. And those of you from this region might recognize my old friend Hank the Cowdog there, who is fond of saying, huh? So the process is not mental health treatment per se, but I think a lot of courts, a lot of prosecutors have over time sort of viewed it that way. Well, we got to get them into mental health care, so we'll start up a competency process. Well, there may be an added benefit of treatment and stabilization with medication for a person with mental illness. It's to be hoped that happens, but that shouldn't be the default look for trying to get somebody into services and treatment. So there's been a big messaging campaign to courts and prosecutors, defense lawyers. Let's look at options and alternatives when we can. Because you know the backlogs. And at the time I sent the slides in, I had data from the end of the third quarter of the fiscal year. We're now past that, right? We're at the end of the fourth quarter, and the numbers have only gone up. So here's some data at the end of the third quarter on wait lists. Non-maximum security, 924. Average length of stay, almost half a year. Over 550 on the maximum security wait list, average number of days on the wait list, over a year. We also had at the end of the third quarter, over 200 people who were only charged with misdemeanors on the wait list. And I understand at the end of the fiscal year, as of August 31st, these numbers were even higher. Well, for most persons with misdemeanors, why aren't they diverting those individuals earlier? If they're misdemeanors, they tend to be nonviolent charges. Couldn't there be another way? Well, the statute, as it's been amended in the last few sessions, the legislature's done a really nice job of teeing up the procedures to try and default where possible to outpatient competency restoration and jail-based competency restoration before turning to going on the wait list for inpatient beds. Challenges are that the statutory structure's there. It's great. Like I said, it tees things up, but we still don't have the number of programs that we need. Only a relatively small number of outpatient competency restoration programs across the state, and their size capacity on number of patients, their dockets, if you will, vary in numbers, but also are not particularly large. Jail-based competency restoration, even fewer programs, and again, small numbers. But it's a start, and the statutory provisions are structured to support more of this, and so the hope is more will be coming. On competency restoration, it's important to know the time frames. I think you're all familiar with these, but it gets complicated. It varies by whether it's misdemeanor or felony. And there was an even greater complication with the jail-based competency restoration, because that statute as passed was that, hey, you can have only 60 days in the jail-based competency restoration program. So let's suppose somebody's charged with a felony. Typically, competency restoration, the period is 120 days plus a 60-day extension. Well, the statute said, well, you only get 60 days in the jail-based program, and then immediately after that have to be transferred to an inpatient. We know that's not going to happen because of the wait lists and the backlog. And so what we were finding is that somebody could be in a jail-based program for the 60 days, and then they go on the wait list. The jail-based program can't provide further services. They're on the wait list a long time. The 120-day clock pauses at the end of those 60. And then once they finally get a bed in the state hospital, the remaining 60, the 120 clock starts up again, and there might be a 60-day extension. But for a number of individuals, the gains that were realized in those first 60 days were lost in that long wait period before the state hospital then would have the opportunity to start over. So something that we got passed in 2021 is that if there's not space available for such an immediate transfer, the individual can remain in the jail-based program and continue to get services in the jail-based program for potentially as long as the period prescribed in the statute. So that was a common sense kind of change. Well, and then the other I've mentioned is at the end, when you are in the state hospital system and the time runs out, the 120 plus 60, or in a misdemeanor, the 60 plus 60 runs out, and the person hasn't otherwise timed out altogether, any further process has to be through a civil commitment order by the criminal court. And that still gives some of the judges and state's attorneys challenges or problems because they're just not used to using a civil statute in a criminal court. I think that's improved, but it continues to be a challenge. Medication hearings can come into play in these as well. And as you know, the additional statute on medication is in 46B086 that allows when somebody is committed for competency restoration at an inpatient facility, there could be a medication under order under that statute. But first, you got to go through the health and safety code process, sometimes called the Texas two-step. Start with the probate judge. It's largely driven by some U.S. Supreme Court decision-making, the Sell case. If that court says no, the criminal court could hear this. So, a number of provisions that are there. A couple of things, and I see my time's about up. I want to list a couple of highlights. On the horizon, and on the immediate horizon, I think are some additional possibilities on trying to reduce these wait lists. One, more public hospital beds. One of the, I think, great things about the third, well, from my view, the great thing about the third legislative special session is that they appropriated a number of bucks with COVID money. So the Fed sent COVID money, the legislature has done appropriations. Some of that, $2 billion for surge staffing at state and local hospitals, including psych hospitals, but also nursing homes, and how that money is going to be spent, I don't know. But as far as the beds issue and the wait list issue, they included an appropriation of over $237 million to build a state hospital in Dallas to try and provide more beds. They provided $40 million for a 100-bed unit out in the Permian Basin area to be operated and run there locally. Being from Lubbock and on the board for StarCare, as Jim so kindly mentioned, we were excited that the bill includes $15 million for an expansion of Sunrise Canyon, which is our 30-bed inpatient civil hospital that's going to add more capacity there for that hospital. All of these together intended to try and help address some of the challenges of treating people appropriately when there are such wait lists. Hope to see more outpatient competency restoration bucks, more jail base, more diversion. The toolkit I mentioned to try and encourage judges to look at these various options. These are challenges that continue as we go forward and will continue to go forward. My time is at an end. I'm going to go one more minute. Insane defense often gets left to the end because it affects fewer people. I apologize if insanity is your thing. Keep in mind, as you know very well here, you have some patients, some individuals who've been found in GRI. It is such a small fraction. It's raised in about 1% of the cases. It's successful about 26% of those. It's an expensive defense to raise, so defense counsel tend not to often raise it. Generally raised in violent type crimes and offenses because much more is on the line there. Even that 26% figure is a bit misleading too, in that far more often, particularly in a state like Texas where our defense is very narrow in terms of language, these are what I call lay-down cases. The prosecutor doesn't contest it vigorously. There's been a decision, oh yeah, John here or Ellen here, the hospital system's probably a better place than prison, and so they don't fight it hard as opposed to it having gone to the jury. But our test is narrow. The variation on the old McNaughton standard, the actor as a result of severe mental disease or defect didn't know the conduct was wrong. Quite narrow. In contrast, the test for kids under the family code is much broader. As a result of mental illness or intellectual disability, a child lacks substantial capacity either to appreciate the wrongfulness of the conduct or conform conduct to the law. Last off, a couple of things. I'm part of a national work group. That's Judge Leifman from Miami, where we're working on some model type provisions of somewhat re-examining some of the standards for, on the civil side, for commitment and then criminal justice pathways. A lot of our current law on standards was enacted in the 60s and 70s, long before a lot of what we know about treatment for mental illnesses. And so this committee I've been working on includes judges and psychiatrists and lawyers looking at trying to come up with some alternatives, and we hope to have a product, if not by the end of this year, early next year. And interestingly, it's been funded in part, our travel and going to meetings, this Equitas project. And I didn't know anything about Equitas, but found out that it was the family that made its fortune from Hot Pockets. Little did I know that Hot Pockets, big deal, made a lot of money. And so they have philanthropy efforts now, including trying to better services and treatment for persons with mental illness. And promise, last couple of slides, the Judicial Commission on their website has some great tools. They have a free resource of mental health bench book. The new 3rd edition came out 2 weeks ago. I'd urge you to go to the JCMH website and download that. NAMI Texas has the link to our guidebook, my guidebook that I've done as well. So thank you so much for your time. I know it's I'm between you and the break, so appreciate being with you. And I believe James is going to come out with a couple of announcements before the next session.
All right. Once again, every time we go on break or right before we go on break, we're going to give out some of these welcoming boxes. I don't know if you can see that right there, kind of like that. They got some cool stuff in them. So, 15 people. Is there anybody that won anything in here earlier? Make some noise if you did. All right. So, every time I announce your name, I need you to stand up and say, woohoo. Okay, number one is Lexi Bardell. All right. And you're probably thinking, how do I win? All you have to do is sign.
Sex Trafficking Team as the North Texas Regional Administrator. That covers 48 counties, including the DFW area, Red River area, and the Louisiana border. She has been working on education, advocacy, and engagement for anti-human trafficking efforts since 2006. She holds a Doctor of Philosophy and Social Work and Ministry-Based Evangelism from Southwest Baptist Theological Seminary in Fort Worth. She also has a Master of Arts in Christian Education from Southwest Baptist Theological Seminary, and she has a Bachelor of Liberal Arts and Science in Criminal Justice from the University of Florida. Please join me in welcoming Dr. Tomi Grover.
Thanks, Jeff. Well, good morning, everyone. I'm a walker, just fair warning. I'll try to stay away from the mic as much as possible. Can everybody hear me okay? Sorry about the technical issues. Can you turn me down just a little bit? Thank you. I'll try to stay in the middle here. All right, are we good? Oh, it feels like the devil's in the details of the tech stuff this morning, doesn't it? Can't get the video to play, can't do all these things. So thank you for being here today, and greetings from the Office of the Governor and the Child Sex Trafficking Team. We are a small team but mighty and cover the entire state, and we'll talk more about that. Just a point of personal privilege, in April of 2018 I had Bell's palsy and I was left with residual hemifacial spasms, and so the right side of my face doesn't work, and yes, I know. I had somebody email me one day after a presentation and say, "Do you know your face isn't working?" And I was like, yes. So just in case you have trouble understanding, wave at me. I can see some of you, and I'll try to repeat what I have to say. So I wanted to bring a presentation to you that will help you to understand what we're doing, what we've been tasked with in the state, but also what the scope of the problem is for our children as we face this issue in the state of Texas, and the kind of programmatic elements that we've implemented in order to be able to address it holistically and comprehensively. So you'll notice on the first slide that I've got a map of the state of Texas with some red dots in it, and this is the heat map from the National Human Trafficking Hotline, and this is where they have received signals or requests for assistance or calls or text from our state. And the hotter, the redder, that's the higher number of calls. And you can see that there's a triangle that sits between San Antonio, Houston, and the Dallas-Fort Worth area. So in North Texas, we play a pretty significant role in the trafficking because of our infrastructure corridors and the traffic that comes through here. That's transportation type of traffic. We also play a hub role for trafficking of human beings as well. So if we could play this for us. We should have audio on this. So I'm just going to go ahead on, because this video is available on YouTube. It was a project that we worked on with the Karen Purvis Institute of Child Development. I'm still getting a lot of feedback on my mic. If you guys could adjust the mic just a little bit. Thank you, appreciate it. So I'll make that slide available to you, and we'll just move on to the next slide to get some definitions out here for us to be able to understand the scope of this problem. So we have a trafficking statute in our state that covers commercial sexual exploitation of children as well. There's always an action, a means, and a purpose, and it mirrors the federal definition. We'll not spend a considerable amount of time on this, but we wanted to make sure that you understood there was a lot of pieces of what happens in trafficking that don't always get a lot of publicity or information out there, but it has to do with the trafficking means is transports, entices, recruits, harbors, provides, or otherwise obtains. And one of the pieces that is often a misnomer in trafficking is that there has to be a third party who traffics an individual. And the reality is, if it's a child under 18 who exchanges a sex act or sexual abuse for something of value to them, which could be a meal, it could be a night on a couch, it could be anything that they need for that particular day. If they exchange sexual abuse for that item, it is considered trafficking, and it doesn't have to have a third party. The actual person who purchases or pays for that sex act can be charged with trafficking as well. So our team was implemented in 2015 by legislative action. So it was the legislature who took the challenge on and developed our team. We sit in the governor's office, in the public safety office of his team, and we have a team of 10 who are working diligently over the last 6 years to make sure that we implement a holistic and comprehensive approach to this. And you'll notice that there are 6 pieces to this. I know it's kind of tiny to read it. It's in your handout. But they gave us a public health framework that helps to guide the work that we do. We're really having some challenges today. It's all good. So there's 6 pieces, and what you'll notice in our icon that was developed in order to bring forward that I'm good with no lights as long as we don't have any fire, I'm good. Those were put into this icon we got to laugh about it. This is hilarious this morning. And I stand between you and lunch, so we're going to try and be out of here at noon, right? So we put it together. I've heard it called This is a Tide Pod because it's the closest thing we know. But all 5 of the public-facing pieces are there. And the 6th piece is the research. So we collect, analyze, and disseminate research that's around this topic, but we also use that research as our evidence base. And it's the research base we use to make sure that these pieces of the assignment that we've been given are being done with appropriate measures and all of that kind of stuff. We do collect a lot of and analyze a lot of research that's going on in this space. And we produce a biannual. Oh, we just gotta laugh. Just gotta laugh. So I'm gonna go through these pieces. You'll note that there is a star in the middle. We're the Lone Star State, so we have to have a star in our products. And we're gonna look at each of these areas pretty specifically. We were really laughing back here earlier about this not working and figured we would have a light show, but it would be with the machines up here. We had no idea that Night Fever was going to be playing in the background and we were all going to be dancing. So our vision is that we have a state where children are free from sexual exploitation, and it's a big goal, but it's a worthy goal because our children deserve not to have to exchange sex for things of value to them or anyone else. And we use those 6 pieces to develop our mission statement to create these sustainable solutions. So Texas size, we've got to have a Texas size response, and as a part of that, we are looking at specifically enhancing our statewide systems. We'll talk more about that. Developing a regional approach and a response that's a local continuum of care. This has got to look really interesting to the people who are online watching as we have this light show going on. Yeah, this is great. So a part of this is enhancing the statewide system, and while the current governor, Greg Abbott, was the Attorney General, he had started the Human Trafficking Prevention Task Force in 2010, and he brought that into his administration for his role as governor to make sure that we elevate this. And as a part of that, we now have human trafficking experts within almost every state system. And you guys know that there's one that's for HHSC. Brandy Sewells leads the work in trafficking for HHSC. And then we have developed many other pieces for the Department of Family and Protective Services. In 2017, we started their Human Trafficking and Child Exploitation team. We also have helped to facilitate human trafficking squads for the Department of Public Safety, as well as Texas Alcoholic Beverage Commission, and trying to make sure that all of the state systems have a collaborative effort. There's actually a statewide coordinating council that was developed by the legislature so that we're not doing things that are different from one another, and helping to get everybody on the same page. That coordinating council meets on an annual basis. So it's like turning the Titanic in some respects, but the work over the last 5 years has been pretty significant in getting all the state systems to align. We currently have 5 regional administrators. We divided the state not based on geographical landmass, but on population densities. That's why I have 48 counties. And my colleague in El Paso has 93 counties. And it's centered here on the Dallas-Fort Worth area, and we began our work in Tarrant and Dallas counties, as well as Bexar and Harris counties, and have really seen the growth of the work since that time. And the 48 counties that I have are those periwinkle colors, and you guys are about my farthest west that I go. So let's talk about these component pieces. Protect is the active word for prevention, and our prevention strategy is used to help us to guide the work in prevention. So we do primary prevention, secondary prevention, tertiary prevention, and as a part of that, we're trying to implement strategies through the Texas Education Agency, and there's been a great deal of work to try and strategize about how we get this to the kids, how we get it to the teachers, and now we're no mic. There we go. Okay, so I'm just going to roll with it. What else do we have, right? We do try to disrupt the market as well, and so when I started looking at this in the context for what you do, I wanted you to see that there are some continuous reasons that we work on strategizing and pivoting when necessary to make sure that we're covering those things that are appropriate. So there's this context of vulnerability for our kids, and any kid with a device in their hands is easily vulnerable to exploitation just because if they have access to the internet, and internet people have access to them as well. And then there's the recruiting and grooming that goes on, and that can be in relationship, and we'll talk more about that a little bit in this session, but definitely in the next session about what that looks like, because there are some specifics about that that you'll want to understand. And then abuse and control, which mirrors domestic violence in many ways, and we'll talk some more about that. Have you guys seen this pair of ACEs, this adverse childhood experiences paired with adverse community environments before? Anybody? Great. It's helping us to frame what we begin to understand about why our children are getting exploited, how they're getting exploited, because there's some adversity that they're facing. And our team at the Department of Family and Protective Services is using this plus another piece of information to understand that there's a wave of activities having to do with the pandemic and COVID that we're living in, and all of those environmental issues that have also come across our children's lives and our own. And there's a lot of reaction to that in the psychological realm that has made our children essentially more vulnerable psychologically, but also the environment within which they're operating, mostly in the online space for education. What year was this building built? It was not made for all this technology, was it? It was definitely not made for this. So we started looking at research that was actually done on our children incarcerated, and this is a study out of Florida, and what we see in this is that the children who are trafficked mirror some of the same vulnerabilities as other children who are incarcerated for a variety of criminal activities, but that their vulnerabilities because of trafficking are much higher in areas that mirror a part of what the adverse community environments and those experiences that they have. But technology means that all of our children are vulnerable, and their access to technology brings a new level of engagement. What I looked at in my research was that there are basically 3 things that are happening. It's a place and a platform for anonymity, And children think that they're anonymous. Also, perpetrators try to mask and gaslight and are trying to be anonymous as well. And that anonymity means that they think that they're talking to somebody that they're not, or they're talking to other people and they are, trustworthy. And so there's a lot of misinformation out there about their ability to talk with people who are their own age and others. And so what we find is that there's accessibility to our kids. And the second piece is there's low protective factors. So our children these days are digital natives. They've grown up in this environment. They are readily accessing on a regular basis the internet and online tools, the apps, all of these things. But that also means that predators are looking for them and are looking for certain clues and cues that kiddo may be in conflict or that they may need. Okay. All right. Now the trick will be keeping my hands from moving. Okay, we'll try this. So there's the accessibility and anonymity. There's the low protective factors of parents who are not digital natives. Most of the parents that we have today are digital migrants. My kids are in their 30s, and they didn't have access to all of this, and now my daughter's parenting 3 who have access. So that's the kind of thinking we have to move towards, is how do we put in place protective factors for our children? And some of the things that we're doing for prevention actually are much more than just sex trafficking. They're preventing the children from getting accessed by others in that space. And the third piece is that this kind of access to technology can flip a child from engaging in non-criminal activity to production of criminal images, whether it's child sexual abuse materials or if it's self-images that they then trade or are exploited for. The National Center for Missing and Exploited Children is one of our primary partners, and they have been doing some phenomenal work in this space, and they have great resources. If you're trying to do some primary education on this to help mitigate these issues for children in your own life or grandchildren perhaps, I would highly recommend the National Center for Missing and Exploited Children's resources on this issue. So commercial sexual exploitation of youth is the term CSEY, C-S-E-Y. We say it's CSEY because it's a whole lot easier than commercially sexually exploited youth. And what we've begun to understand is that our children are getting accessed by trusted adults in their life or who they thought that they could trust. And it's not just stranger danger that we need to be aware of. While we have a lot of interaction in the internet space with people who we don't know, there are also people in their sphere of influence for these kiddos that are utilizing them in order to gain access to money, drugs. I saw a lady in East Texas who sold her child for a new vehicle. And we have a lot of exploitation that's happening with our children that goes undetected many times because it's a family member who seems to be able to groom the entire system into believing that they're a trusted adult. So one of the elements of trafficking is force, fraud, and coercion. And coercion is one of those that's really difficult to prove. A lot of coercion is psychological. So there's that manipulation that bonds that person to them. There's also the coercion of their inability to leave, and then they manipulate them into believing things that aren't true. And they also use that element to include drugs, alcohol, and sometimes even food to coerce them into activities and participation in commercial sex. So it now applies to all forms of human trafficking if there's elements of coercion that can be found in that case. Also, there are new protections. I brought some of the legislative updates that our team put together. Todd Ladiolis on our team is our public policy and prevention specialist, and he's helped us to understand what some of the new legislation has brought forward. And folks with mental and
mental disabilities have been elevated as a key component for our understanding, to be able to make sure that we don't miss them as potential victims of trafficking. There's other research that's out there that has highlighted the fact that a developmental disability can make a child vulnerable, because someone will take advantage of what they don't understand and exploit them in commercial sex. Some of our prevention efforts are focused on primary areas across the state, Boys and Girls Clubs, one of those, and our targeted prevention education has been working with those that provide specific training. Love 146 is a curriculum we use. Protect is another curriculum that's available. We've been working with the Texas Education Agency to make it applicable for our schools across the state, and have begun saturating the state through the work of TEA and the educators across the state. I was in Melissa yesterday teaching the ISD about understanding this issue. And there's a lot going on to make sure that this is a part of what they teach directly to the students, but also to their staff and faculty, to make sure they understand this issue. And then we have our C cities, which are cities empowered against sexual exploitation. And this has begun a brand new coalition on the issue of demand for our state, because you have basically the demand for the product, and those who are willing to sell the product. The three tiers of the demand abolition focuses on this particular aspect of what is out there for the market. This is more on the school-based education specifically. You can see that they've tried to layer in amongst all of the educational elements what it looks like for them to have a knowledge base that allows them to see what they hadn't seen before in what might be presenting at their schools, and how to effectively make it possible for them to address this issue. Also, there's new no trafficking zone signs, just like there's no gun zones around schools. They've also implemented no trafficking zones, so that if a person is recruiting or engaging in recruitment or enticing kids at a local school, they can also be charged additionally on top of the trafficking pieces. So demand is a piece that got a lot of action this time in the legislature. And prior to 2019, the buying and the selling of commercial sex was the same charge, and it was a misdemeanor. And we're the first state in the United States, thanks to this current legislature, that has now a state jail felony for the purchase of sex. That's a big deal. That's a really big deal. Yeah. Thank you. Thank you for the legislature seeing that we needed to address this more effectively and not penalize the sellers when especially we have figured out that most of them are not in a situation of selling sex because they've chosen that. It's because they've been trafficked as kids and they're still in the life as adults. And the reality is many of our women who've been arrested for prostitution or selling sex, because it's an elevated, after 4 charges of misdemeanor, it's elevated to a felony. Often they end up with doing time in our state jails, and they don't get the kind of treatment that they need in order to be able to come out of the life well as they progress in that. But our state jail felony will be it's already implemented, and we've started to see some operations going on. Fort Worth has, at the Tarrant County Sheriff's Office, a human trafficking task force that was federally funded last fall, so they've been operating for about a year. And they had an operation 2 weeks ago now that they arrested 115 buyers in a week-long operation. So that we have 115 cases in Tarrant County that we're going to see how the district attorney's office handles those, and then we'll have some case law on that as it moves forward. So how much is the demand? Well, this graph kind of gives you an idea. This is from our partners at the CEAS Network, And what they're looking at is Houston, Austin, San Antonio, and North Texas. And North Texas is the greater DFW area. And this is unique ads per month. So it goes from 0 to 150,000. So in North Texas, we had well over 100,000 unique ads per month for the sale of sex. Almost all of those are online. That's how they find these. And they have tools to help research this now. And it gives you an idea of the number of people who are out there looking to purchase sex on a regular basis. The demand is huge. It's going to take a cultural shift in the purchase of sex in order to make a change in what's available out there. Part of what we've done in the prevention area is to put together resources. The Bob Bullock Museum used to be that all 7th graders would go to the Bob Bullock Museum down in Austin, and since COVID, there's no one going to the museum. So when they put this together during the pandemic, they decided that they would make this a mobile display. And what it is telling the stories of survivors of human trafficking, both labor and sex trafficking in our state. And they've got a wonderful display of what has happened to some of our survivors as victims of trafficking. And they also have ways that people can recognize it and ways that they can help. We have had a great deal of success in showing our Be the One campaign video that was produced by the Office of the Attorney General. If you haven't seen Be the One, I would highly encourage you to look at that. If you get the opportunity to either go to the Bullock Museum or see the mobile, or would like to request from them that the mobile unit come to your area of Texas, I would recommend that as well. A social media campaign just went up this past week. We're working with the McCain Institute out of Arizona State University, as well as the First Lady's Office and the Outdoor Advertising Agency. They have given us 70 different billboards across the area and have been utilizing both the electronic versions with multiple depictions of this campaign, but also static billboards. We did a public press release yesterday in Laredo and had some great opportunities to talk with local constituency there. And tomorrow we'll be in Grand Prairie doing one of these so that the local community can get awareness as well as prevention education. This is an ad that is Real Friends Don't, and it is both parent-facing as well as child-facing. It's got some really good robust resources available, and I'd highly recommend that you go to the website Real Friends Don't and get a look at that. One of the pieces of addressing trafficking, I've been doing this since 2006, that really helped to frame this for me in a much more specific way was learning about talking about human trafficking as a public health issue. Since we're living in a pandemic, a lot of us are much more aware of what a public health issue is and how we have been seeing this put together and responded to. And as a part of my work over the years, I've participated in a group called Heal Trafficking. For those of you who are in mental health and medical health and any other discipline that touches on the mental or medical health components, I'd highly recommend that you explore Heal Trafficking. It's HEAL trafficking.org. And they have a very targeted approach for a public health framework, and they're educating medical doctors, they're educating RN faculty members who teach nursing. They're doing a lot in the mental health area, and they have a whole group that focuses on the response of the mental health community to trafficking victims. What we find is a lot of our victims go to medical facilities and their victimization looks like something else to the providers. And if they come forward saying that they're selling sex, there's a lot of shame and other kinds of stigmatisms that are preventing them from accessing healthcare well. And so the mental health component was an additional layer that the medical facilities and the medical doctors realized that they needed help to understand how this presented in their emergency rooms, in their mental health clinics. What does this look like? How do we address this? Dr. Jordan Greenbaum is one of the most prolific in this area. She has put together a screening tool that is designed for the medical community, and it asks just basically 6 questions, but it is focused on physical health. But it has a couple questions that can be addressed by the mental health aspects. What they have done is an evidence-based research on the tool, and it's getting a lot of traction in a variety of our medical settings. And it's been a way of approaching this to get a team of mental health experts to work on this topic with much more specificity as to how it's addressed. This presentation is really just an overview. I'm trying to help you to mine some diamond locations of getting more detail. And I can help you with that if you get stuck somewhere. Just let me know. I definitely can help you to find some of the HEAL trafficking resources. So in about 2009, I met Jonathan Todres, and you heard in my introduction that I'm a graduate of the University of Florida. Go Gators. And this guy is a law professor at Georgia State. So if anything good from Georgia ever came out, it was Jonathan Todres. I'm glad you get it. Jonathan Todres is a law professor, and he has been working on describing the commercial sexual exploitation of children since about 2007, 2008 as a public health issue. He also writes about it as a human rights issue with a global context. But he worked with Dr. Angela Diaz, who's a medical doctor, and they wrote this book. It's called Preventing Child Trafficking, A Public Health Approach. It's one of the best that I've seen on embracing a public health approach and giving specific and intentional direction on how to respond to this issue with an approach that helps to get upstream. Jonathan has an article called Upstream that really began his discussion of this, and I've given you on your handout the link to that, where you can go to his website or to the SSRN paper cache of Moving Upstream, the Merits of a Public Health Law Approach to Human Trafficking. This embraces all disciplines. And a part of what I wanted you to see was that there's some intersectionality for all disciplines who address victims with mental and physical health problems, and that a comprehensive strategy that's inclusive of a multidisciplinary response is really the best way that we know to grasp what the depth of this problem is and how we can respond to it holistically. So with that, there's the socio-ecological model that he talks about, which includes the individual, their relationships, their communities, and society. And you'll see that as a part of our approach, this is some of the things that we're attempting to do in the prevention. Remember, we're still on the first of the 5 pieces, and I want you to understand this really guides a lot of what we do in understanding the depth of the problem and how we can respond to it. All right, so that was protect. Everything else from this point on goes a little bit quicker, especially because I'm standing between you and lunch. I'm glad we got the lights worked out. I'm glad the microphone's working. Looks like we're on a roll now, right? Okay. How many of you have ever played Where's Waldo? Yeah, I see some hands. So we've got the Waldo collage. But what do you need to know about Waldo in order to find him in the collage? What he's wearing. Yeah, what he's wearing. And then when you find out he's wearing red and white stripes and those big old glasses, and you start looking at the collage, what's everybody wearing? Red and white stripes, right? So a part of recognizing is seeing what we haven't seen before putting together the puzzle pieces and knowing what we should be looking for. We're going to talk about the commercial sexual exploitation identification tool when you come back from lunch. I wanted to give you some pieces of understanding that we have to know what we're looking for in order to know how to recognize this. And so we have a pretty good a response to this that includes that public awareness campaign that's both preventative as well as recognition. Then we have targeted training, which is the commercial sexual exploitation identification tool. And the training overview that I do today will give you information on how to access the training if you want to begin implementing the use of the See It tool. Also, we've been providing the See It tool training for entities that are youth-facing all across the state. We have thousands of users that have been trained over the last several years, and I'm going to show you some of those results. And then we do some data collection that helps us to visualize where our trends are with that information. So quite generally, victims of trafficking do not make an outcry, and the See It tool is evidence-based. It was research-based by the West Coast Children's Clinic, and they found that their children in the study were exploited for 2 or more years, 3/4 of them, and that 3/4 of them didn't even understand what exploitation was. They thought they were in relationship with their person who was exploiting them, or they just didn't understand that that was what was happening to them. And about half of them were under 14. 14, y'all, that's middle school, right? So we have to be thinking about the youngest of children and preparing them for resiliency in this space. So part of what we've done in the Recognize area is to make sure that all the entities across the state are speaking the same language about trafficking, that they have similar signage, and that there is training available. So we're looking for every entity that has some touches in the public to make sure that they have training. You get your commercial driver's license these days, you've got to have some trafficking training so that you understand what to look for when you're out there. You have licensure that's regulated through Texas Department of Licensing and Regulations. There's trafficking training and experts in their field who are able to help to define that. So there's lots of ways that we're doing many things to help folks recognize trafficking victims, because they just hide like Waldo in the collage sometimes, and until we know what to look for, we don't see them. That human trafficking signage legislation that went into effect already this year will align every signage piece that comes out of all of our statewide systems, so that no matter whether you see it on the back of a stall in a restroom and along the interstate, or if you see it in a public school or anywhere else, that it would be posted similarly, and it will have guidance on who to call. And it won't be Ghostbusters. Sorry, it's been one of those mornings, right? We just gotta go with it. So we will talk more about the commercial sexual exploitation identification tool at 1 o'clock when we come back. But know that there's a lot of evidence to indicate that these kiddos are hidden in plain sight, and we need to know what to look for. We'll be looking at the 8 key indicators when we come back, and we'll be looking at what the outcomes are, just so we get to prepare you for thinking about what is a child presenting like that has some risks. And we'll look at the Lighthouse Initiative and that data collection piece that helps us to start framing what our trends are, what we see, and how that is portrayed. So the third piece is recover. So we've looked at prevention, we've looked at recognition, and now we're going to look at recover. It's hard work to do the recovery, and our state has implemented some really awesome advocate agencies to begin having an effect on the recovery portion of this, and we've been working on a lot of pieces to help us. So we're looking at ways that we can support commercially sexually exploited youth, and we want to make sure that they have access to resources, because even when accessing resources as an adult, it can be difficult, and having the right support system in place really does make a difference for these kids. We are also working with a variety of agencies and entities across the state that do drop-in centers. We will have our first emergency assessment centers opened probably early next year, We are looking at an assessment center in Dallas at the Letot Center that is going to be operationalized by Juvenile Justice Services, and it will be a place of assessment for psychological issues. Dr. Madeline Byrne and Dr. Leilani Hinton there are our experts, and they work with CSA kiddos, and they're helping us to have a way to interrupt where they are when they're recovered on the streets of Dallas and their surrounding area. And then we're developing care coordination teams. So I'll unpack this one just a little bit more and let you see how we're working on this. This is the stages of change. You guys familiar with this stages of change and how this operates? So most of us understand this when we put it in the context of something personal. And it's when we know we have a challenge and we aren't ready to address it, or maybe we come to the place where we are ready to address it. And a lot of our kids don't understand that they're in a situation that they need to make some changes from, and so they may be pre-contemplative. And then if they are picked up on the street and have an opportunity to get supportive services, they may realize that they need to make some changes in order to not be victimized anymore. So we use the stages of change to demonstrate willingness and readiness, and to help them to move along the spectrum of recovery as a part of what we're doing in the state by working with the agencies that work in direct contact with the kids. So I'm not going to spend a lot of time on this, but it's worth unpacking. If you are working with kiddos and you don't understand why they're not wanting to change, or that they don't have the motivation to change, we have paired this with motivational interviewing, and motivational interviewing training have been done by Baylor University for us, and we have some experts in motivational interviewing that helps to move kiddos through the stages of change so that we get better results on a quicker pace. We don't quite know what the minimum dosage is quite yet, but we are working towards having an evidence base that between motivational interviewing and stages of change, we can see progress with our kiddos coming out of the life. Part of what we have to begin recognizing is trauma bonding. This is not the same as Stockholm Syndrome. Trauma bonding has more roots and tentacles into the psychological aspects of what someone who is manipulating or exploiting an individual may do to them in order to get them to comply. So we have recommended this training. It's called Understanding Trauma Bonds Between Traffickers and Their Victims by Amanda Gopal. It's available for free at the National Criminal Justice Training Center. It's one of the best that I've ever attended. And she shows how trauma bonding is like a thread that wraps around and draws that kid into the situation of exploitation, but furthermore keeps them in bondage to that individual who's exploiting them. Power and control wheel, once again, there is a power and control wheel about trafficking issues specifically that I would recommend that you take a look at, because it has a lot of these same elements. The challenge is for a kiddo who gets bonded to an individual, especially if it's their first romantic relationship and they're also engaging in sexual activities with that individual, there's a level of bonding that is physiologically a part of what happens in that relationship as well. So trauma bonding, Amanda, who does clinicals with victims of trafficking, said this is probably the most difficult area of helping a child to see that they've been manipulated and that they're bonded to somebody who's actually toxic to them. Highly recommend that training. Our research from University of Texas has demonstrated that these kiddos are hurt in relationship and that they will heal best in relationship. Partners at Karen Purvis Institute similarly say that these kids need a trusting adult in their life in order to recover fully. There's a lot of attachment issues that they address in the trust-based relational intervention training that they've developed specifically around CSA. And we know that a supportive adult can help that child. So as a part of that, we've begun implementing CSA advocacy, and that's commercially sexually exploited youth advocates. These are specifically trained advocates who, most of them have master's degrees, some of them are clinicians, a lot of them are working towards their licensure, or that they have already been licensed, and they are a field-based advocacy program. And there is no other state who's providing this. We learned this model from Saving Innocence out of Orange County, California, and they only serve Orange County in California. They don't serve any other state counties. But in Texas, right now, we have about 17 agencies who are serving across the blue counties. And we have 2 here in North Texas, Traffic 911 and Unbound, which are currently serving 6 counties only. The amount of kids in the Dallas-Fort Worth area is tremendous. We have hundreds of kids in Dallas alone that we're recovering on a regular basis, and so their scope of services are confined right now to those 6 counties. It's Dallas, Tarrant, Collin, Denton, Ellis, and Johnson. Those are the 6 primary densest populations in the North Texas area. But as a part of this, they're field-based, and they respond when law enforcement has a child on a particular operation, or that they have recovered in a hotel or situation in the field, and they're responding usually within 90 minutes, often less than that. And if you get anywhere in the Metroplex in 90 minutes, you're doing good, right? So they go to where the kiddo is. If the law enforcement needs them to come to the hotel, they go there. If they need them to go to the hospital, they go there, and they accompany that child. They don't take the place of any other advocates. They do like what sliding scale case management might look like, where they work with other advocates across the state, because advocates are not all equal, and nor do they stay with that child for the duration of their healing process. But CSAE advocates are specifically case managers that come at the point that that child is identified, and they stay with them over the long haul, no matter who else is addressing their needs in those areas of law enforcement, or if it's a CASA volunteer, or if it's others that may be a part of their life. We also have these specialized centers, the emergency assessment centers. There's going to be 2, are not on this slide yet because their funding just got released last week. And yet we're working with drop-in centers to provide 24/7 access so that kiddos don't have to exchange sexual abuse for things that they need. We have a brand new one that just opened a year ago in Fort Worth. It's called The Underground. It's at the One Safe Place, which is the Family Justice Center. It's open 24/7, and they're doing a phenomenal job. They offer food, clothing. You can stay for up to 24 hours. It's an unlicensed facility, so they're not doing housing overnight, but you can go and find respite there, and they do some phenomenal work. You notice that almost everywhere those centers are mirror what I showed you at the beginning of the presentation, where the heat map is. That's what we kind of refer to as the golden triangle between Harris County, Bexar County, up I-35, up I-45, here to the Metroplex and the North Texas area. 287 is a primary corridor because you get north and west from here, right? So I know that in the last 10 months, I believe there's been 3 cases in Wichita Falls alone. It's not somewhere else, it's right here. One of the other pieces in recovery that we've implemented along with the case management is survivor care coordination. And care coordination is kind of caulking between the cracks that the system provides, and it brings all the players to the table. And as care coordination has developed, we've expanded this across the state, and we're working with the Children's Advocacy Centers, because the Children's Advocacy Centers, according to the Family Code, are the designated entity that coordinates all multidisciplinary team investigative staffings and the coordination of that care for the kiddos who have been victims of any crimes in our state, but specifically sexual assault. And so this is a part of their work, and yet we're asking them to expand their capacity to also serve these kids that are high risk and who are identified as clear concern, and that they're providing options and opportunities for new players in the community, stakeholders that can serve those children's needs that are beyond the the care of the Children's Advocacy Center. So care coordination is like the air traffic controller that gets all the people around the table to make sure that the coordination of services for that kiddo are implemented in their local community. We've had some additional legislative pieces that have come out, as well as the Family First Act from the feds, and there's a lot of capacity building that's going to happen in order for our state to address this for our kids who are also in conservatorship with the FPS. We believe at this point, based on our numbers, that about half of our kids have either had contact with the FPS or are currently in conservatorship with the FPS. So the fourth element is supportive healing. We can do all the recoveries all day long, but we don't have holistic ways of dealing with the supportive healing. We're not going to be able to meet their needs physically, psychologically, any of those things. And it requires a lot more intentionality because their traumas are so deep. And we know that fight and flight and freeze are all a part of the way that our kids are responding to their situations. So just imagine for a minute how difficult life must be for these kids who've had such trauma, complex trauma. It's difficult for human beings to have resilience when the traumas just keep coming. I think we're all kind of experiencing that with the pandemic. We're all feeling a little overwhelmed. But imagine being sexually assaulted numerous times a day by people who you don't know, and having some sense of normalcy has got to be elusive. And the triggers that are out there, the healing process is going to take a lot more than just a kind, adult. It's going to take a whole system of people around them to help them to recover from this. So our friends at Karen Purvis Institute, like I said, they are working with us to do trust-based relational intervention and to provide a mechanism by which we can stop asking what's wrong with you and start asking what's happened to you. It's a mind shift. And there's still a lot of the blame and shame and all the other things that we're going to have to change socially in order to see these victims as victims and to treat them that way and to help them to thrive and survive and to have a virtuous adult with whom they can connect and grasp that they can have resiliency in that. So highly recommend TBRI. If you haven't taken that training, it's available online as well as the in-person events that they have. It's an excellent training. So in order to provide specialized supportive healing, we've also worked with those that have residential treatment centers and have specialized care for kiddos who've been exploited. We have these across the state, and again, mirroring the Golden Triangle, tried to have them where the kids were most likely to be recovered. There are case management programs, there are residential programs for adults, and then we have down on the lower left the 10 residential programs that are serving youth. We work with them on grants, we work with them on measures, we work with them on outcomes. We are doing a lot of specific things to try and research the model and the modalities that they use. We work with them to try and make sure that they're using cognitive therapies that are appropriate and helping them to gain access to those treatments as providers. That makes their center different for these kids, and TBRI plays an important role in that. So the actual long-term supports are comprehensive. There's physical issues, there's psychological issues, but there's a whole host of other things that this child may be facing, maybe some criminal charges that are on them while they were being victimized. We do know that we have kiddos who are incarcerated during their victimization. They were perpetrating crimes on behalf of their trafficker. We're working towards making sure that they have options and opportunities to recover, even if they're having to stay within that system. But we're also doing pre-arrest diversion and other programs that are allowing them to have options as well. So we're looking at how do we raise the capacity of a local community to respond. A part of what we have going on even in Wichita Falls is the development of a coalition of like-minded people who want to address this in their local community and provide supportive elements that will help those children to recover. There's legal issues, there's financial issues, there's all kind of things that follow these kids, and we want to make sure that we're working supportively. The Texas Workforce Commission has some specialized folks that are working with our team to make sure that they have people who are trained to understand the needs of a person who's been exploited and how they can get job skills, life skills, and readiness for employment as well. So the Bring Justice piece is the last of the 5 public-facing pieces, and we're working with the various law enforcement, but also the judicial components, the judges, the permanency court judges, the folks who have any influence in the juvenile justice system and how it operates and functions. We are working with Texas Juvenile Justice Division and have been working intentionally to make sure that they have been trained on the See It tool, which we're going to talk about when we come back from lunch, as well as many other options for placing children in a specialized setting. So our law enforcement community has been working to make sure that they are addressing trafficking. The Department of Public Safety in 2009 started doing interdiction for protection of children. My favorite folks in the whole wide world are DPS. When you put children and DPS in the same sentence, they are like on it. Their criminal investigation division has really been forward thinking about understanding what this looks like at the street level. So every trooper in our state is trained to recognize if they make a traffic stop, a kiddo who might be missing or being exploited. When they make that traffic stop, within the first 90 seconds of the traffic stop, engaging with those people in the car, they're making assessments about whether this child belongs there, maybe a missing child, and they've recovered over 500 kids since they started doing that training. It's been an important part of how they've strategized to make sure that they are looking for missing and exploited children in our state, and they've begun training even internationally on how to recognize that. We, again, are working with a variety of partners and making sure that they have the tools that they need in order to prosecute these cases and that they know how to make cases well. Hopefully, our work with Collective Liberty will produce a number of new cases that will be not relying on the victim to have capacity to testify. What the Fusion Center is working towards is training law enforcement on how to go after the bad guys and to let the professionals who work with the victims help them to recover and to become resilient, good witnesses when a court trial might come up. But they're also working towards making sure that the district attorney's office is able to prosecute the cases based on the evidence that they bring forward without even having to put the child on the stand. That's important because, especially if they're trauma bonded to their trafficker or have had some kind of romantic relationship, or maybe even have a child by that person, it's hard for them to testify against them. So if we can make the case against the trafficker without having to have any of that, we're much further down the road and making sure that justice is served and that person doesn't have the opportunity to victimize anyone else. The Fusion Center works on gathering intelligence based on what's on the internet and open source materials, and then they're building up their data and their knowledge about traffickers by working with the Department of Public Safety and other publicly available data. We're also working with them to implement a research project that will be a part of the Massachusetts Institute of Technology, Lincoln Labs. They have some strategies for using artificial intelligence that will help to guide what we do on internet crimes against children. I'm going to tell you, we can never law enforce our way out of this situation. The amount of exploitation that's going on online and the amount of internet crimes against children are too much for law enforcement to ever be able to grapple with those numbers and to keep up with where the cases are. So we've got to come up with a tech solution that helps to minimize victimization and to go after the bad guys who are perpetrating there with a level of information that is only available in that sphere. Otherwise, what we have is law enforcement personnel who have to go through terabytes of information and look at horrific images. And if we can get the intelligence of the computers to look at that and not have to victimize our law enforcement officers, but also go deeper and more quickly, I think we're going to have some things there. And so between Lincoln Labs and MIT and the Fusion Center, our law enforcement capacity to work on these cases is really elevated. So in order to combat those emerging methods, the National Center for Missing and Exploited Children has continued to work with those that are in social media and to address this issue with them so that they are also working towards, or at least they say they're working towards, minimizing the amount of victimization that happens on their platform, right? So they have worked with Facebook specifically, and they have elevated this issue at Facebook to make sure that they are looking for and screening and pulling anything that is images of child sexual abuse materials. I do want to make sure that you know child sexual abuse materials as a name is now taking the place of what used to be called child pornography, so that you make that shift in your thinking and your descriptions, because child pornography is a term that doesn't describe child sexual abuse. It describes activities of pornography. And so we want you to understand that child sexual abuse materials is the new language going forward to talk about children who are being abused and captured on video or in pictures. It's a real problem. 1 in 4 kids were victims or younger when they were threatened. So online extortion and threats. There's a really great video at the National Center for Missing and Exploited Children about how this works. Child meets somebody online, they ask for a picture that's nude, and she's made this relationship with him, and then he demands more and videos and exploits her for more and threatens and coerces her to giving him those, or he will expose her publicly on social media platforms. And then 1 in 3 have not told anyone. This is pretty typical of child sexual abuse, period, but the online exploitation and the online engagement, kids think that they're responsible for having engaged with somebody where in reality they were exploited online, and they just don't understand what that is. So this is a piece of what we're having to address as well. The group called Thorn, thorn.org, it's the website that's at the bottom, was started by Ashton Kutcher and Demi Moore. You may have seen him give testimony to the feds on child sexual abuse materials. And this has really become a passion for him. He's made sure that there's a lot of research based. And our own Dr. Vanessa Boucher from right here in the Metroplex did a considerable amount of research with them as the principal investigator. And one of the things that they found in the research was that the majority of children who were trafficked as 10 and under were trafficked by family members. Let that sink in just a minute. So the younger the child, the higher the likelihood that they're trafficked by a family member. So that could be a parent, could be a custodial kinship, it could be aunt, uncle, brother, step, whatever relationship there. So actions to take. If you recognize someone who's a victim of trafficking, you can call the National Human Trafficking Hotline, that 888-3737-888 number. If you think someone's in imminent danger, call 911. Get law enforcement out there to assess the situation. Does it mean that every law enforcement officer will understand what you're trying to describe or what trafficking is? Maybe not yet. But we do want you to if you see something, make a report, say something. Watch the one video. You'll see how that actually played out in several locations across our state when somebody saw something. If it's non-emergency, the human trafficking hotline, if you just need more information or if you just want to make a referral and you don't have enough information. But if it's a person who is in your care, custody, or control for any reason, and you believe that child has been a victim of sexual exploitation, then we'd want you to make a referral to statewide intake, Department of Family and Protective Services or law enforcement. As a mandated reporter, that's what we would be doing, even for any other situation as well, if you know that there's a child that's been a victim of crime. So we have implemented what's called iWatch in Texas. This is run by the Department of Public Safety, DPS. I get all those acronyms and they start to run together. DPS, DFPS, HSSC, all that alphabet soup, right? So iWatch is a non-emergency way for you to also report criminal activity that you may be seeing. It is available online as well as a telephone number. It's in your packet, but it's the 844-643-2251. If you see something and you just want somebody to know about it because you're not sure what it is, but they'll take a look at it, the Fusion Center. And then, of course, if you see something online and images online, you can refer to the National Center for Missing and Exploited Children's cyber tip line. It's online, and you can give them the information about what you saw, when you saw it, where you saw it. They're scanning images daily, and since COVID and so many people have been online, it's been a multi-fold increase in the number of reports of child sexual abuse images that they're seeing. One of the other pieces that we've implemented in the state is a survivor leadership council, where we have a number of now adult survivors, many of whom were trafficked as children, who are giving us guidance. We don't know what we don't know until we ask those who have lived experience. And as a part of what we have done is, with intentionality, asked survivor leaders to keep us informed, to give us their perspective, and to guide us into the areas that we need to improve. And I think that this council has served us really well. They're partnered with the Texas Alliance Against Sexual Assault, and they've really given us some great, valuable information and guidance so that we do the best by our survivors and help them with their services. Once somebody is recognized as a survivor of trafficking, if there's charges on them, they have some options now for specific charges, not all charges, but specific charges, where they can do orders of non-disclosure as well as request for clemency, and that was just implemented last year. If you need more information on it, there's information on your website, or that you can contact our team and we'll be glad to help you with that. Early on, we developed a roadmap for our communities to understand what it was that we were unfolding across the state, and that map is available. It's digitally on our website to help you to know how we're working, what the public health framework is, what it looks like, how we're addressing these issues, and things that you might be able to do in your local communities if you're not in an area that already has care coordination, or if you want to maybe work towards getting a coalition together. It's getting the like-minded people who want to address this in their local community an opportunity to do some things on prevention education or recognition, public awareness, those kinds of things, and building the capacity of that community to respond. I'll be meeting tomorrow with your local Children's Advocacy Center as well as your local Rape Crisis Center. Actually, they are headquartered in Wichita Falls, but they serve about 8 and 10 counties in this area, which means they have a pretty broad reach and a scope of work that can be valuable if you live in this particular area, and if you need access to any of our other 25 plus coalitions across the state because you come from somewhere else, just look us up on the web and you can find where our coalitions are from our team. We also provide, through our team, this is one of my responsibilities as the team academician, is to put together a biannual assembly of research that we have found in the 5 areas: prevention, recognition, recovery, supportive healing, and bringing justice. And we look for basically low-hanging fruit. I use, here's the cheat, I use Google Scholar alerts a lot. So if you're looking for research, you can put in the terms that you're looking for, and I get hits almost every day, especially during graduation season, right? December and May. And another thing that I use is what Heal Trafficking is putting out, because it has both the medical and the psychological public health framework, and we're looking always for the research that they're doing on assessment tools and other ways of engaging with these survivors. And we put this out twice a year. It should be out in the next couple weeks for the second iteration. And from it, we're trying to make sure that we stay true to the model, that we're getting evidence-based and research-based implementation of new and fresh ideas, and that we're course correcting if we find that we're headed in the wrong direction, that we can pivot and make a change to what we've got going on. We also do webinars. It's on the second Thursday of the month at 1 o'clock. We've had some great guests. Even Dr. Jordan Greenbaum has been one of our guests before, talking about her screening tool. We've had many guests from across the state that are working on this issue and try to bring relevant topics so that you can grapple with a variety of things and get some assistance if you need it with special information. So this is our team. This obviously pre-COVID, photograph, but we are a team of 10. We have half of us in Austin, and then the rest of us are dispersed across the state, as I showed you on the map earlier. And I think that one of the challenges for us is we're like one of the best kept secrets in the state, that people don't know that we're implementing this public health response to trafficking, and we're working towards making sure that others get to know of the work that we're doing, and how we can help to make that happen in our state. So I have left just a little window of time, because I know lunch is pending, but I wanted to see if there was any questions from the field that you guys might have. I want to apologize for the technical difficulties that the IT guys tried overcoming, and they succeeded. Thank you, gentlemen. Appreciate you. Yeah, and the lights, we got that worked out. It's been quite a show this morning. All right. You want to come and give them some instructions about what's going to happen now and for lunch, and what they're responsible for, and I bet he's got some more giveaways. Thank you.
How about another round of applause for Dr. Tomi?